So what we will be looking at in the next hour or so is, first of all, is it development at all? In other words, is it a material change of use? Is it operational development? And if so, if it is development, is it permitted development? In other words, is it development that you don't need planning permission for, so that you can go ahead with it without approaching the local planning authority? Alternatively, it may also be permitted development where you need prior approval from the local planning authority. Now, that means that whilst the principle of development is agreed, you may need to ascertain whether or not you need details of the design, effect on the character of the area, etc., and need prior approval from the local planning authority itself. So it won't need planning permission as such, but prior approval. And in most cases, if the local planning authority doesn't agree to the prior approval, or rather doesn't deal with it in a particular time frame, then it will be necessary for you to go ahead, or you'll be able to go ahead without waiting for their approval in the end. In other words, you apply for a prior approval, the local planning authority doesn't deal with it within, say, 56 days, then it will be deemed to be approved, rather than the situation where you apply for planning permission, where it is deemed to be refused and you have to appeal against deemed refusal. Now, I say that in connection with most permitted development rights where you need prior approval, but there are some more recent ones where, in fact, if the local authority doesn't deal with it within a specific period of time, it is deemed to be refused in the same way as it is with planning consent or planning permission, and you would need to appeal against the deemed refusal. Well, we'll be looking at that in a lot more detail, obviously. We'll be looking at the use classes order up to 2020. We'll be looking at the post-2020 changes and other recent changes. I'll be looking briefly at whether or not, and in most cases you should, apply for a certificate of lawfulness of proposed use and development under Section 192 if you're not sure about the situation. We'll look at how the local authorities can exclude permitted development rights, either by Article 4 directions or by conditions attached to planning permission. We'll be looking at the possibility of you being negligent. Goodness knows, I hope that doesn't happen, but the ways that you can avoid that, and particularly looking at proposed changes in the future, because the government has issued a consultation paper on extending yet further permitted development rights. Now, in addition to all this, you will find with your papers, you will find some 4 multiple choice questions which you can deal with at the end of this webinar, and I hope they'll be of some use to you in working out what I've actually said and what's gone on in this webinar.